Good afternoon. My name is Alina Shavtsova. I am an immigration attorney from Brooklyn, New York. In today's legal speaking seminar, I would like to talk to you about recent Board of Immigration Appeals decision of Mendoza Hernandez and significance of that decision. Basically, what happened last year in summer was that the United States Supreme Court held that when the government sends to you deficient or issues a deficient notice to appear. A notice to appear is a charging document that starts your case in immigration court. Deficient in that it does not contain date and time when your hearing is going to take place, but states TBD, to be determined. That is basically a null and void situation, and your immigration proceedings do not start, and your stop time rule for cancellation removal does not start running, which is very important. And we were all very excited to receive the decision in the summer of last year, and based on that decision, many people were able to reopen their cases because now all of a sudden they realized they were able to receive a cancellation removal relief. And some judges dismissed cases because deficient notices to appear were certain people. So everybody was very excited in the immigration community. But slowly but surely, the other side started to push back, arguing that, yes, there was a defective notice to appear issued, but then we sent, or the court sent, a hearing notice stating that you must appear in court on specific date and time, and that cured that deficiency in the notice. And guess what happened? Recently there were a number of decisions, and the recent one I just mentioned was issued on May 1st, 2019, stating that yes, if you received a hearing notice, even though the notice to appear itself was deficient, if you received a hearing notice that did contain date and time when you were supposed to come to court, that cured the deficiency of the notice to appear. So this is where we stand now. I know that many people were able to reopen their cases based on deficient notice to appear. And now with these cases where we say, where the Board of Immigration Appeals states that deficiency actually is excusable because it was cured, I'm sure that the government is going to file motions after motions saying that those people who were able to reopen the cases, if they did receive a notice like that, they would not qualify any longer for cancellation of removal. Now, you need to keep in mind, though, that at times those hearing notices come to a wrong address, do not come to your address at all, because there was no address on file, and it was not your fault that there was no address on file, or they come years later. It happens at times that the hearing notice comes years later because your case was forgotten, or the proceedings were terminated, or different situations could have happened. So not every case is the same. You still have to order file and see what's in your specific file. But this is an important decision because it's basically going to deprive many people of the relief they hoped for, and we need to know about that decision. Perhaps there will be federal court litigation regarding this issue in the future, just because the interesting point about all this thing is that when you first read the US Supreme Court decision, it seems that, yay, you will have an opportunity to argue that many people actually will qualify for the relief. And then, as always, lawyers carved out a point, and this is going to be government lawyers who said, no, wait a second. But later there was a notice sent, and you don't qualify for the relief that you thought you would. And you can learn more about various situations in immigration laws and points that you may need to know for your case on our website, www.shaltsova.com. Thank you.